Good morning, everyone. Welcome to today's webinar, A New Approach to Customer Contracting, How to Protect Your MSP from Liability, sponsored by Scott & Scott, an intellectual property and technology law firm located in Southlake, Texas, also voted Technology Law Firm of the Year USA by Finance Monthly. Your presenter today, Managing Partner Rob Scott, advises technology companies of all sizes offering cloud and managed services with risk balancing and regulatory considerations. Today's presentation will be recorded and you will receive a link in the next few days. Please enter any questions in the question box and Rob will answer as many as time allows. For those of you wishing Illinois, California, or Texas CLE credit, Diana Peterson will follow up with you after the webinar. You'll receive a short survey requesting feedback on today's webinar and your ideas for future topics. We'd appreciate hearing from you. There is additionally a handout for California CLE credit applicants to fill out and return after the webinar is completed. Now introduce you, Rob Scott.
Thank you very much, Marcus. I appreciate everybody joining today. I'm excited to talk to you about customer contracting in the context of managed services and cloud. I have been working in managed services and cloud for about 15 years now, and I've been serving as an advisor on the board of advisors to the MSP Alliance for over 10 years, and in that capacity have had an opportunity to represent many members of the MSP Alliance and other MSPs and cloud service providers, and as Marcus says, ranging in size from single technician startups to some of the largest technology services firms in the world. And today we're going to be talking about the risks inherent in offering managed services in cloud, which are greater today than they ever have been, and a different approach to mitigating those risks as we move toward a modern approach to contracting, which allows you to align your sales process with your contracting process such that once your sales process is completed, your customer contracts are completed as well, and we'll talk through that. But why is it important to have very detailed and well thought out and thoroughly reviewed customer contracts? Well, the risk landscape it's very broad. You have risk from competitors, you have risk of customers, for example. If there's a data breach or other incident involving your customer's data while you're the managed service provider or the hosting company, vendors and channel partners, many of you are aware that certain of the RMM tools have recently been compromised, creating a lot of problems for managed service providers. And many MSPs resell other partner services. They're not just in the businesses of offering proprietary solutions or professional services, but rather bring a number of different solutions to bear for customers. And sometimes those solutions cause injuries to customers, and the MSPs can be caught in the middle. Like all businesses, the employees of managed services providers and hosting companies can be a source of risk. For example, if an employee has access to a customer's network and is using that access for inappropriate purposes, that could create a problem for the employer or the MSP in that context. Similarly, many customers of MSPs believe that anything that goes wrong with the IT network, regardless of the cause, is the responsibility of the MSP, including criminal acts of third parties, which could include hacking incidents, ransomware attacks, and other theft or phishing, variety of different activities from a criminal context that could implicate a customer's environment and put an MSP potentially at risk. So we're going to talk about these various sources of risk, and in some ways we'll talk about how contractually you can mitigate these risks as you move forward with your business. So risk management is really something that MSPs have to be thinking more about. As I said, back in the day when I first started, MSPs were mostly, professional services consultants that did their work on a best efforts basis with very limited warranty other than workmanlike warranty, and really had very limited risk associated with offering the services. And today, really, the landscape for managed services is fraught with risk. And in order to manage that risk appropriately, there are 4 primary tools that you need to be thinking about. And first and foremost is your customer contracts. I mentioned that I've been doing this now for 15 years, and I would tell you to this day, the number one first engagement that we have with new clients usually starts out with a conversation like, hey, we'd like you guys to look at our customer contracts. And it's because that, in my experience, when managed services firms get sold, they're primarily being sold in asset as opposed to stock transactions. And the primary asset that's being sold is the customer contracts. And so the details of those customer contracts become very important in the context of due diligence and ultimately have a major impact on the enterprise value of the MSP's business. And so customer contracts are critical. Most MSPs recognize it. Some have taken the steps to invest time and energy in making sure their contracts are where they need to be, and others, still have an opportunity for improvement. So your customer contracts are critically important, and they not just any off-the-shelf, services contract for IT will do. There are very specific provisions that MSPs need to include in their contracts. Specific things that they identify that are included, specific things that are excluded, very carefully worded warranty and limitation of liability and other risk balancing provisions, which we'll get into, are very important in the risk management strategy when it comes to customer contracts. In addition to that, policies and procedures, and in particular, auditable policies and procedures that third parties can come in and validate, are becoming increasingly important. And as MSPs begin working in regulated markets, and as they begin providing services to more and more sophisticated customers, what we see is a greater need for third-party verification of the policies and procedures that the MSP is using to ensure that customer data will be safeguarded and protected. And so those policies and procedures could include a comprehensive written information security plan. It could include a data breach incident response plan, and it could include a acceptable use policy. And in many instances, the insurance underwriters are going to want to see your policies and procedures to make sure that you have appropriate policies and procedures in place before underwriting your insurance, which is the next important tool. And I think about insurance from the perspective of managed services in the same way that I think about malpractice insurance for doctors or attorneys. Professional liability insurance, also referred to as E&O or errors and omissions, is very important coverage for MSPs to have, and they should specifically include coverage for cyber-related risks. So those would be data breaches, those would be data losses, those would be ransomware attacks, etc. Excuse me. And then the fourth category for risk management involving managed services is the regulatory risk. And over the last many years, we've seen literally an explosion of rules related to outsourcing of IT. And so in the context of healthcare, for example, we have the HIPAA regulations that require an MSP to be a business associate and sign a business associate agreement. In the financial services context, we have GLBA, which requires the financial services service provider to legally obligate themselves to be bound by the regulations, including the privacy and safeguard rules that are contained in those regulations, and specifically to implement appropriate physical, procedural, and technical safeguards to preserve and protect customer data. In addition to the sort of federal vertical regulations that we've seen for many years now, we've also seen a rise in data privacy regulations, specifically that are more consumer oriented. The best example of that is GDPR, which is the European General Data Protection Rules. And since GDPR became effective, we're starting to see states passing their own data protection laws, including California recently passing what we refer to as CCPA, which is California Consumer Privacy Act. We've got the New York Shield Act, which is a similar privacy regulation. So in the context of managed services, if you are providing services to regulated entities, you don't have the appropriate data processing agreements in place, you don't have the appropriate compliance initiatives in place, then that places you at a regulatory risk and potentially places your client in a regulatory risk situation. So this is a significant category. But when you're thinking about risk management through these four tools, will be very helpful for you in understanding how to operate your business without taking on undue risk. So the title of this presentation is a new approach to customer contracting. Well, the substance of what we've been doing in terms of how we go about documenting the services that our MSP clients are going to provide to their customers really hasn't changed that much. We've added, things here and there for ransomware and different things that have come up. We've got, very specific language about, backup and disaster recovery, and, we continue to tweak them. But what's new is the ability to go to web-based terms, which will allow the customer to sign whatever it is that you're normally presenting to them, whether it be a proposal or a quote or a statement of work, that doesn't have all the legal terms and conditions, but more at a business level describes what you're going to be doing for the customer. And when that customer signs off on that, we incorporate by reference all of the related terms and conditions, and we present those via the web. And so what happens is you now are able to get your customer to sign whatever it is that they would normally sign, but through working with us, we're able to take the documents that you're already using and create a hook into a fairly sophisticated and comprehensive modular stack of customer contracts that cover a broad array of services that are typically offered by MSPs and cloud service providers. And what we have learned is that nobody is exactly the same. And while we have, very good agreements, a lot of the work that we do with our clients is taking our sort of industry standard and industry leading set of contracts and really walk through the client and make it very specific to their business, how they want to offer their services, how they want to describe their services, what policies do they want to have in effect in terms of how they deal with their customers. And then, of course, we talk about the risk balancing provisions of limitation of liability, indemnity, and insurance. These are sort of my big three pillars of risk balancing. And what I think is that managed services providers should not be taking on any significant risk that's not transferred to insurance. And what I mean by that is MSPs should acquire an appropriate level of professional liability insurance coverage, including cyber liability. And in the customer contract, that insurance should drive the bulk of the risk transfer that the MSP is taking by limiting the liability to either proceeds of insurance or the greater of the proceeds of insurance or some small amount tied to monthly services for a short period of time. And then the indemnity language, that's the language that describes under what circumstances the MSP will pay for claims against the customer. And we generally like to take that language directly from the MSP's insurance policy. So in a lot of ways, the insurance policy is a policy of indemnity. It describes under what circumstances claims will be covered. Those claims are by third parties. By definition, that means indemnity. And we like to drop those same conditions, those same triggers for indemnity into the MSP's customer contract, thereby aligning the coverage with the obligations in the agreement, so that the MSP is what I refer to as being in the zero risk position, which is they've taken on no additional risk via their customer contract with their customer than what they have transferred to their insurance. Very important concept in how we look at customer contracting. It's not just about what's included and what's excluded. It's not just about what you're responsible for and what you're not responsible for. In the end, it boils down to these three provisions in terms of if something goes wrong and there's a claim, who is going to be responsible for paying and what limits or caps will be applicable. So, here's an example of a stack of agreements that we would typically recommend to a cloud or managed services provider. And what we find is that our MSP clients frequently will be using a quoting tool, Tiger Paw, Quozel. There are many industry-leading quote generating tools. And there are in many instances associated with an RMM solution. And we work with our clients to update those quotes and proposals that are coming out of their quoting system to create a hook via a technical process called incorporation by reference, which basically says that, in the quote and the proposal, we're calling to these other documents and having the customer acknowledge that these additional agreements will govern the services to be offered under the quote or proposal, and that includes the master service agreement. In the more traditional approach, the master services agreement was the signature document, and all these other service attachments were literally that. They were attachments to the master. Now, what we've been doing is driving everything through the quote or the proposal, and the master agreement is itself online as well. And then under that, you'd have your managed services agreement, which would be what we sometimes refer to as core managed services. This is the kind of service that an MSP would offer the base service to all of their customers. Some people refer to it as core managed services, but this is monitoring, management, patching, updating, bug fixes, antivirus, the core plumbing and maintenance of the networks would be governed by this agreement. And then we have a separate attachment for backup and disaster recovery. Many of our clients are either offering a proprietary backup solution, while many others are reselling one or more third-party backup solutions, and our agreements are designed to accommodate an unlimited number of flavors or approaches to backup and disaster recovery. Increasingly, and I think for good reason, many MSPs are beginning to offer add-on security services above the core managed services for antivirus and so forth, but offering things under a managed security services agreement, including managed firewall, security awareness training, could be some penetration testing, could be some other, non-standard managed security services, could be log monitoring, could be SOC, Security Operations Center services. Those would be typically governed by a managed security services agreement. In addition, many of our MSP clients are either cloud solution providers themselves, offering private cloud solutions on or developers of proprietary solutions that are hosted in the cloud, and others are reselling third-party public cloud and offering traditional hosting services, data center services, and we use a cloud and hosting agreement regardless of whether it's a private cloud solution that's being offered or a proprietary cloud solution that's being offered by our client, or reselling of third parties, or a combination. And with our cloud and hosting agreement, we cover both data and voice. We have a number of, as you can imagine, MSPs that have come up, on the voice side of the business and are transitioning to data or adding data, and others that have come up on the data side and have incorporated cloud-based voice solutions. And so our cloud and hosting agreement covers both data and voice-based solutions. And then many of our MSP clients also offer sort of T&M consulting services, hourly engagements or project fees for upgrades or designing a new solution. And so our typical stack of agreements will include a statement of work that could be used for hourly or project in fees. And then finally, in many instances, we're including a service level objectives agreement. You'll notice that this is not a service level agreement in the traditional sense. And in my opinion, the days of service credits and so forth that we got stuck with sort of out of the legacy telecom world really are not that appropriate for most managed service providers who really are in the business of providing response and not necessarily resolution, particularly where there are a number of third-party solutions that are involved and they're not in a position to be responsible for resolution. So, uptime and availability, all those things can be important concepts if you're in complete control of the entire solution, but rarely these days are the solution providers controlling the whole solution, and therefore very difficult to have a service level agreement when you're not in control of all of the aspects of the delivery. And so we offer an agreement for service level objectives that goes to response times and severity levels and when people will be available, but doesn't get into requiring the MSP to resolve a particular issue in a particular time, or typically do not recommend any kind of service credit concepts, which we've seen historically. So we have, as I said, over the years, created a number of very industry-specific provisions related to managed services contracts that we develop for our clients. And the first one we talked about earlier is incorporation by reference. What this does is allows us to leverage the quote or the proposal without having to present the customers with a giant stack of contract papers after they agree to the quote or the proposal. We've got provisions in our backup and disaster recovery contracts that deal with the requirement for customers to maintain local backups. We've got language in our agreements that says that if the customer is hit with ransomware, the customer has the option to either pay the ransom or pay the MSP to remediate, but can't make the MSP remediate without additional compensation while at the same time refusing to pay the ransom. We also have provisions that deal with early termination. And if you sign a 3-year deal and you want to get out after a year, then you can't just get out for free. Create some stickiness, create some value in that long-term contract by making it difficult for a customer to get out. If someone comes along and offers them 10% less fees than what they're paying you after you've already gotten everything set up, well, our early termination and liquidated damages provisions make it a little bit harder for customers to do that. In addition, we've had many clients that have gotten in trouble at the end of a contract with a dispute, and one of the things that we put in our contracts is that transition services are not to be provided unless all the fees, including the early termination fee, has been paid in full. There have been so many cases I've been involved with where we get to the end of a contract, the customer is demanding all these transition services, at the same time disputing the obligation to pay any termination fees, or maybe they're saying, I'm not going to pay you fees that I owe you for months that have already been incurred unless you agree to do these additional services. And so, we've addressed that by making it clear that at the end of an agreement, the MSP is not obligated to provide any transition services unless all fees are paid. We talked about the no liability for third-party goods or services, but this is incredibly important because in many instances, the customers look at the MSP as being responsible for anything that goes wrong, regardless of whether it's their solution or not. And even you recommended it to me, and therefore, if it goes wrong, it's your fault. And I just fundamentally disagree with that concept. I think that it's not the MSP's responsibility for everything that goes wrong, and the MSP should be responsible for that which it controls, and the customer should bear that responsibility, which it would otherwise have if the MSP wasn't there. So if, for example, the customer wants to be in the Azure cloud and the MSP is facilitating that, but there's a data breach at Microsoft, that doesn't mean that the MSP should be responsible for that. And the MSP is facilitating a relationship that the customer would otherwise have directly. It should not be adding, a layer of insurance between the customer and Microsoft. It's facilitating that relationship. So this is critically important to make sure that your customer contracts don't put you in the middle between the customer and the vendor, because the vendor's agreements most certainly are limiting in terms of liability and what they're undertaking legally. And what you don't want to be is in a situation where your agreements are not similarly limited, such that something goes wrong by a third party that you brought to the table, and now the customer wants to hold you responsible, and it's really not your fault because it's really a failure of a third party. The other thing is we've been in many, many cases where a client will over deploy software that it should have been, paying for to the MSP, and a third party will come along and do an audit. Say, for example, Microsoft will do an audit of a service provider license arrangement or a cloud solution provider arrangement, and suddenly the customer's been using way more than they've been paying for, and Microsoft wants, for example, the MSP to come out of pocket and pay, but in some instances, the agreement between the MSP and the customer would not permit the MSP to go back against the customer and recover those monies that Microsoft, for example, demanded. And so in our customer contracts, we've addressed that issue with any kind of third-party claims that come along through audits or otherwise. If the MSP is required to pay, there's a right in the contract to go and recover those monies that were associated with the client's use from that client. So we talked about risk mitigation in the context of policies and procedures, and I mentioned these three types of policies, and I think every MSP should have a written version of these policies, and not just something that gets written and put on the shelf, but things that get operationalized within the business so that everyone within the organization can understand, what is our information security policy, how does it map to, other standards and regulations, and what is our breach incident response plan, And is that something that could be in writing and shared with the customer who's asked about it? And then to the extent that we're offering solutions online or doing any hosting, what does our acceptable use policy say that customers can and can't do? And if you don't have these agreements, we certainly can help you get started with developing them. We've got templates that we can start you with, and then, of course, customize to your needs. As I said, in many instances, clients will come to us and say, I want to get managed services insurance, and the underwriter in the application is asking me, do I have these policies and for copies? And so in many instances, we develop these policies for MSPs that are in the market to get insurance because it's part of the underwriting process for good reason. Speaking of insurance, as I mentioned, I think every MSP should carry errors and omissions insurance, which also includes a cyber liability coverage component, which means that if there is a data breach incident at one of the MSP's customers, that the MSP's insurance will answer for that. And I think that's, like I said, tantamount to professional malpractice insurance or medical malpractice insurance. And I think every MSP that is serious about their business really needs to have that type of insurance. And if many of our clients have gone through the MSP Alliance program, available at mspalliance.com, and they have a program through Beasley. We have a number of other clients who have used an agency called TechRug, which specializes in offering technology insurance for managed service providers. And my advice is to shop around and get the best policy that fits your needs, but to ensure that you've got an errors and omissions policy that includes cyber liability. The other thing that's important is the use of first-party coverage for customers. And what first-party coverage is coverage that the customer would buy to cover the customer's data in a situation, for example, where there's a data breach or a security incident that's not the fault of the MSP. The MSP's professional liability insurance is only triggered if the data loss is the subject of an act or omission committed by the MSP or its employees. But as you know, many security incidents occur for other reasons. For example, employees or criminal acts of third parties. And so the first party coverage is coverage that protects the customer in the event of a claim related to data security or privacy that isn't the fault of any third party vendors. It's just they had a data loss, they had a data breach. And I like to include in my customer contracts the obligation that the MSP's client agrees to carry cyber liability insurance and to make their cyber liability insurance, the first party cyber liability insurance of the customer, primary over the MSP's E&O insurance. And that way, it's a good conversation to have with a customer to say, look, I have E&O. It only covers if I'm at fault. But there's a lot of things that could happen where I won't be at fault, and you need to have your own coverage. So that's a very important part, the insurance, and that's an important discussion that MSPs need to have with their customers. And the existence of good managed services insurance, I think, gives the MSP a competitive advantage in their ability to structure their terms and conditions relative to MSPs that don't have good and tailored insurance coverage. So we talked about the data processing agreements, and you'd be shocked now at how much legal work there is involved in just reviewing, drafting, editing data processing agreements, because it seems like every transaction is a maze of regulations, and it's unclear exactly, from the face of a deal without digging into it further, exactly which regulations apply. But these are the ones that we deal with most commonly. And for our clients that are MSPs that are operating within these regulated markets, we help them develop data processing terms that they can then make available to their clients, either by presenting them, via email, or in many instances via, web-based terms, but they comply with these regulations. And that way, if the MSP has a client that is subject to these regulations, then they can demonstrate that they are capable of working with that particular client by not only entering into the appropriate DPA, but gaining a thorough understanding of the underlying regulations and the requirements of those regulations, and then implementing policies and procedures to ensure that if they were called upon to do so, they would be able to demonstrate their compliance with these various regulations. But all of them have some basic underlying similarities, which is if you're going to provide IT services for a business, you're going to be bound by the same regulations as that business, and you will implement the appropriate safeguards that are necessary in the same way that the entity that would be covered would be required to do under those regulations. And that's the whole purpose of these privacy regulations and these data processing agreements, is to essentially allow the law to reach the service provider through the customer, where the regulation might otherwise not be amenable to reach the MSP. In other words, the organization that promulgates the GLBA is a banking organization in the United States, or a group of banking organizations, and but for the nexus with those financial services firms, the banks and so forth, they wouldn't really have jurisdiction to regulate the activity of managed services. And so a lot of these laws, I think the European Union GDPR is the greatest example, is just a way to expand the jurisdictional power of the regulator. And there's no better example than GDPR, which, as I look at it, is you've got this European Union that has essentially passed a law that is a global regulation. It's very difficult not to comply with it, because you, in many instances, don't know whether or not you're subject to it. I ask an MSP, do any of your clients have any EU data subject data on any of the systems that you monitor, manage, or consult on? And if they're being honest, they would say either yes or I don't know. It would be very difficult for an MSP of any substantial size to say unequivocally that there is no such data in their customers' environments, because in many instances they don't really know exactly what those customer records entail. So the states are involved. California CCPA, New York Shield, these are both very recent sets of regulations, and following in some ways in the mold of the GDPR. So how do you put all this together, and what is a way that you can approach this in an integrated way and ensure consistency across all the risk management responses, and develop something that is appropriate for each risk source? And I would tell you that in addition to what we talked about, trade secrets and other things that separate your business from others, and that could be the configurations of how you configure networks. It could be a number of different things that set you apart. Very important to make sure that in addition to your customer contracts, you're thinking about what's going on with your trade secrets and your confidential information. The other thing to think about is it doesn't make a whole lot of sense to carry a lot of insurance and then put your customers in contracts that significantly limit your liability, because what you're doing there is you're paying for a premium for example, to get $1 million in coverage. And then if you put your customer in an agreement that says, for example, the customer is entitled to no more than 6 months of fees paid to you, then in a lot of ways you're paying for insurance to benefit your customers on the one hand, and on the other hand, you're using your customer contracts to limit the ability of your customers to access that, which in some ways doesn't make a lot of sense. So we've got some time now for some questions, and I'll be happy to answer any questions that anybody has. And just going to take a minute here and pause, so we'll give everybody an opportunity to use the questions on the right-hand box to type in whatever questions they may have. And while we're waiting, I'm going to go ahead and see about this first question. So this initial question is related to the concept that I was just discussing, related to the relationship between the limitation of liability under the contract and the value of the insurance. So, and in answer to your question, they are related. The insurance is set in the contract between you and the insurance company, and it's expressed in terms of typically an aggregate limit. So it'll say, you know, you're buying $1 million of professional liability or $500,000 of professional liability, and that could be a per incident, you know, per claim, and an aggregate limit. And so what that means is you got $500,000 worth of coverage or $1 million worth of coverage, and if you've got one claim, and that's $1 million, it could be consumed that way. If you've got 10 claims that are $100,000, it could be consumed that way. And so because of that, many people will want to limit each individual client's ability to access the aggregate limit under the insurance by expressing in the limitation of liability some other metric, like a number of months of fees, for example, that would otherwise limit the liability. And so ultimately, to the extent that the limitation of liability is valid legally and legally enforceable, which, you know, there are public policies in many jurisdictions that sometimes restrict the MSP's ability to limit liability in certain circumstances. But assuming that that is, you know, legally viable, then it's the limitation of liability that will control legally, as opposed to what the insurance provisions provide. The next question is about the recording. And yes, the recording will be made available. It will be sent out to you via email, and it will contain a link. And we typically post the webinars on the YouTube channel for Scott and Scott. So you will receive a link and you'll be able to review the recording. So this next question talks about how the contract and the agreements work together, with the agreements being online and the client isn't being presented with the agreement. Can you expand on that? Sure. So the client is being presented with the agreement in the nature of a list of agreements and URL links. So the customer, you know, when they sign their quote, there'll be an exhibit that will say, this quote is subject to the following agreements, and those agreements are online. And so, when we say it's not being presented, it's up to the customer to click the link and review the specific terms, but they're agreeing to those online terms and conditions when they sign the quote or the proposal, and that's how the two are tied together. The order says This order is subject to the contracts that are listed on Exhibit A. On Exhibit A, there's a list similar to the list in the slide that I showed you, and with that list is a specific URL that the customer can click on to go actually see those terms and conditions. So that's the answer to that question. The next question is, if someone is interested in having their customer contracts reviewed by Scott & Scott, what steps would they take to do that? And we offer a complimentary initial review. You can email your customer contracts with your goals or any questions that you have to either me or my assistant, Diana Peterson, and we will take a look at what you're using, explain how they differ from what we're recommending, and if it's appropriate, we can make a proposal to assist you with updating or starting over with your customer contracts. And excuse me, we typically charge a fixed fee that's quoted at the outset to do the customer contracting work. I'm going to pause here and wait to see if there are any more questions. And then I want to thank everybody for joining today. And if you'd like to get in touch and talk further about any specific questions that you may have, our contact information is here on this final slide. And you can email me at rjscott@scottandscottllp.com, or you can call me at 214-999-2902. That's my direct dial number. And if you're interested in learning more about Scott & Scott or signing up for our technology law update newsletter, you can do so at scottandscottllp.com on the web. And with that, we have no more questions. And so I thank everybody for joining and look forward to talking to you again very soon. Thank you very much.